Good morning. Thank you, Desiree. As Desiree mentioned, I'm the chair of the Commercial and Bankruptcy Law section, your section, so thank you very much for participating in your annual seminar. And I'm going to start with, I guess, the call to action or the ask ahead of time so that you can think through. It's early morning. We need to, you need a little bit of prep time on this. So I'll first start by saying I will be rotating out as chair this summer, and a new chair will be coming in. But the section council is asking for your input and your advice or your hot topics that you'd like the section to address over the next couple of years. And I get to compete with the train this morning, so hopefully you can hear me okay. So go ahead and think about that this morning while you're logging into your emails and getting your coffee going, because these topics certainly, I'm a diehard fan, right, of garnishments. I mean, who doesn't wake up in the morning thinking, woo, garnishment legislation, can't wait to get on that one. But these came up because of needs from the section. So I just encourage you, if you've got things you really want them to look at over the next year, we're gonna take notes of that at the end of the presentation. And maybe you've got issues you want to war game today among the group that's here, because all of you look a lot smarter than I on many of these topics. So with that, I'll go ahead and get into the presentation itself. As Desiree mentioned, I was the chair. For a couple of years here, we ran into opportunities to address some of our legislation that we work with in our practice areas, creditors' rights, and those two are both the Garnishment Statute and the Uniform Fraudulent Transfer Act. Here's the agenda for the day, and then we're adding number 3, of course, for hot topics, so we'll take notes and take that back to the section council. And I like to do themes. When I do presentation, it's something they teach you in law school to have a theme for mock trial and stuff. So that high school mock trial abuse has stayed with me now in my practice. So today's theme is really a space theme, a galaxy theme. And for those of you that attended the federal bar seminar last fall, forgive me, same topics, Dallas. If you need to take a call, totally understand. And if I missed something, please chime in. But the first topic that instigated the garnishment statute change was a case, Gemini, still new and Gemini. And so the Gemini kind of rang with me, and here we are. We have our galaxy theme, right? So this is the constellation Gemini. That's all I know about it. I was a sociology major. All right, so the Gemini quandary. How we got to the legislation. Judge Viator for us in 2012 heard a case of New versus Gemini Capital Group and Nyman, Stone, and McCormick. And the key there is there's a law firm named as a defendant. So keep that in mind. That obviously drew a lot of attention to my malpractice shareholder at the firm. So we were looking at this one and seeing where this was going to go. Essentially, Judge Viator's ruling in that case stated that Iowa Code 642.14's provisions were unconstitutional. 642.14, of course, is our garnishment condemnation provisions, notice provisions to our debtor, right? Yeah, we totally all knew that. So we put together a working group back in 2013 and 2014 to address what we thought were the issues identified by Judge Viator. That working group consisted of a number of players, including the Bankers Association, Sheriff's Association, Debtors and Creditors Council, and a few of the professors as well, because this was coming to light at the Uniform Law Commission level as well. So we had a lot of input there, and many of you who are here today or joining us on the web may have been involved in that working group, and thank you very much for all of your feedback and wargaming the minor issues. Each of the details that came out of those discussions made our job a lot easier on the Hill because we had already fielded many of the concerns. So thank you to all of you that were a part of that. So before we get into what the legislation does, I want to give you the facts on the Gemini case, because a lot of that deals with the changes in the law really deal with the procedural changes. It's really a sequence of events or a sequence of timing of when you send your notice out, or who sends the notice, or who and how all of those interrogatories get filed. So some of that is relative to where Gemini, the facts of Gemini, where that all started. So looking at Gemini, the case actually started as a very simple credit card collection case of Story County small claims, right? Sears sues Phil New for racking up charges for his tools and toolbox there at Sears. Phil New loses, and judgment's entered for Story County, or excuse me, for Sears, it's Gemini, and Phil New appeals. He wins discretionary appeal at the appellate court level based actually on a statute of limitations argument. They blew the statute of limitations by 1 month. But during that appeal, so actually he ends up winning the state court case, and he's pretty fired up about it, right? He's empowered. But during the appeal itself, Gemini, the creditor, is executing on the small claims judgment. They send a bank garnishment out to Wells Fargo, and the sheriff, they get a hit. The sheriff's holding the funds from Mr. New's account. Because of the appeal, Gemini's counsel never actually goes to condemn the funds. It just sits with the sheriff, right, for the 120 days. So because they never actually condemn the funds, no notice of garnishment is sent to Phil New. So the old statute, 642.14 at the time, only required Phil to get notice of the garnishment 10 days before your application to condemn the funds was filed. So Gemini and Sears, they never surrendered, have the sheriff surrender the funds over to them, and the sheriff actually returns the funds to Phil. Now, we are going to get to federal court. Phil New didn't think that this was right. He brings an action in the United States District Court for the Southern District of Iowa against Gemini and the law firm, saying that this is a violation of his constitutional rights under 42 U.S.C. 1983 and the Fair Debt Collection Practices Act. The allegation essentially is that the creditor and the law firm violated his due process rights by garnishing the bank account without sufficient notice, right? So the question is, his funds were held for 120 days, no notice. That's a violation of my constitutional rights by you, the law firm, and the creditor. Defendants think, that's bizarre. We file summary judgment. They argue, 1, we're not a state actor. 1983 doesn't apply. And 2, we complied with 642.14 at the time. We didn't have to send a notice of garnishment until 10 days before we condemned the funds. Summary judgment denied. And here's the holding, the key holding, Judge Veeder, New versus Gemini, it's a 5/2/2012 ruling. And that May ruling pretty much kept the 1983 and FDCPA claims alive. The case settles later, just in case you wanted to jump to the conclusion. Case settles later, but here's the holding from Judge Veeder that caused the section some concern. 1, judge says 642.14, the way that you complied with the law at the time, it's not a defense, it's still a constitutional violation. This violates a debtor's due process rights. And then the court found that there was state action to support the constitutional violation because you as the creditor are participating with the clerk of court and the sheriff in executing the garnishment. There we go. That's pretty much how we get to at least the 1983 claim and the FDCPA claims stay alive. And the holding was that 642.14 is unconstitutional. And there are 3 reasons that the judge, that we picked up anyway from the section, 3 reasons it's unconstitutional. And this is what we kind of focused on when we were looking for a fix. First, at the time of the deprivation of Phil New's bank account, at the time that it was at the levy, there was no notice. The notice at 10 days before condemning funds is too late. So he didn't have notice at the beginning, and 10 days before condemning funds is too late. So what's the right amount of time? The judge says the notice must be reasonably calculated to apprise a party of the pendency of action and afford the debtor the opportunity to object. So somewhere between 0 day and 120 days was our window, a reasonably calculated notice in order to satisfy those due process concerns. Second, the court said there were no notice of exemptions provided. Third, at the time where notice of exemptions at the time that your account was frozen, the judge's opinion was that you needed to provide notice of those exemptions at that time so that the debtor could come in and object. And then lastly, The fact that you provided the notice for the hearing at the end, most of our notice of garnishment forms back then had a notice of a hearing opportunity and explained that to the debtor on that form. But the judge says the fact that you're giving them that opportunity at the end before you condemn their funds after it's been frozen for 120 days, unconstitutional. So that's what we're working with from the holding. And this is what this is the plan we put together. We put working groups together in 2013, right after, about a year after that holding went into effect, and we were working with it in the practice out there in the field. And then we put together a working group both that summer and the following summer to revise the statute. The goal was really near-term and a long-term goal. First, we need to address 642.14 and what Judge Vader had concerns about, and then the section council also looked long-term. John Kramer, thank you for being in the audience. Those of you that want to be in the long-term working group, he's here to take your volunteers. But we also determined that we needed some long-term fixes and review that execution statute, the chapter altogether. So that's what we came up with, and we started first. Our first attempt was a 2014 amendment. And then we also did a second attempt, which were the 2015 amendments. So I'll start with the 2014 amendments, our first try at all of this, and then we had some issues, so we gave it another shot, and I think we've got a good fix on the second try here. So here's the first amendments were in 2014. Those amendments did a few things. First, we added a pre-condemnation notice, so a front-end notice. I was 642.14a. So in the life of a garnishment, you usually would have your post garnishment notice at the end. That was the old 642.14 where you'd send your notice to your debtor before you condemn your funds. The 2014 amendment added an additional notice on the front end. So you provided notice to the debtor on the front end right when you were freezing their account, and you had the notice on the second end, on the back end too. The other 2014 amendment required the sheriff to serve that front end notice within 7 days of serving your garnishee. So a typical garnishment, I'm a creditor attorney, so I'll walk through kind of just a standard bank account garnishment. We have a judgment, we go through our precipice process, we execute with the sheriff, we deliver our documents for execution with the sheriff. Sheriff goes out to Wells Fargo, delivers the garnishment documents to Wells Fargo. Wells Fargo will then have 20 days before they have to respond to the sheriff on answering those interrogatories. The key there is when the sheriff delivered, under the 2014 amendments, when the sheriff delivered that execution to Wells Fargo, the sheriff then had 7 days to turn around and serve Phil New, or the account holder, with that notice of garnishment. What was happening there is sometimes Phil New, or the debtor, was getting notice before the bank had even a chance to process and levy on the account. So that's where we have 2015 amendments. But just that's where that was coming, where that came from. So that's the pre-garnishment notice where the sheriff then, and you were required to use the sheriff, was required to serve the notice of garnishment to the debtor within 7 days of the lending institution or the garnishee getting notice. The other amendment, 2014 amendment change, allowed notice to be served by personal service or restricted and certified mail. And then we also required notice to be served to the debtor and the debtor's counsel of record. So those were the key 2014 amendments. And I just note that the wage garnishments were not impacted by the 2014 amendments. However, there were some questions that came up following these amendments. There were some questions and some additional redundancy and costs that came up, and we heard a number of concerns throughout the year through the section members and even county attorneys and sheriffs about this process. So we took another crack at it. Here are the 4 main concerns that came up. First, the timing, which is what I just referenced. First, notice was being served on the garnishee or the debtor before the garnishee was responding. So oftentimes the debtor was receiving a heads up, or more importantly, you were spending money to send a notice out to a debtor potentially on a bank that didn't even have funds or didn't even have an account for a debtor. So John says, Christina, I am paying to send the sheriff to send out these notices when I don't even have potential account that's being levied on. Gotcha, John. Good point. So the next issue we heard is the creditors are still in the dark. The creditors' counsel were defendant in that new versus Gemini case. The fact of the 2014 amendments didn't change that fact. Creditors were still in the dark because when the sheriff was serving those notices of garnishment or the garnishment writs on the banks, we still weren't getting notice maybe until the end of the garnishment that actually happened. Those affidavits of service from the sheriff, there were no requirements for them to file those or give those to the creditors' counsel. And those of you that have assistants who have called out to the sheriffs or called out to the banks to try and find what's the status of the service of my garnishment, you know what I'm talking about. It can range from sheriff doing it within a week to a couple weeks to we'll get back to you at the end of the garnishment. So there was still a concern that creditors' counsels were on the hook still for not having this notice to those debtors properly served. We still had a constitutional problem here. Third, we had some inconsistent fees in application. Some people were, some of the sheriffs were charging double for the pre and post garnishment notices. Some folks were only serving both notices up front. So we thought, and it was duplicative. When you read Judge Vietor's opinion, the concern is really at the time of the garnishment, at the time of the deprivation of property, you know, are they getting the notice and the opportunity to be heard to challenge that? And then we heard a lot of confusion on whether or not the pre and post garnishment notice applied to the employers. As you know, wage garnishment is a different statute. So there was still a question of whether for wage garnishments you needed both pre and post notices, or how were the employers supposed to implement this. So those were our concerns with 2014, which brought us to 2015 amendments. And this is the state of the law as it is now. So this is the practice pointer portion where here is in practice how the statute is now applied. So summary number one, there is one notice of garnishment to the debtor per garnishment now. Can you send a pre and post garnishment notice? Sure. But the key is under Judge Vietor's decision, you need to send your notice of garnishment to your debtor, which we have a new form for, at the beginning of your garnishment instead of the 10 days before condemning the funds standard. Serve it at the beginning now. Let's see. We'll talk about the timing of that here on point number 4. But there's one notice of garnishment now, not two. Number 2, we distinguish the notice requirements between employer and non-employer garnishments. Essentially, 642.14b just says, hey, this doesn't impact any of the wage garnishment statute that already sets out the procedure for that. So this is strictly non-employer garnishments procedure. Lending institution, non-party garnishment, or a non-party, my mom inheritance, that sort of thing. Not wage, not employer garnishments. Third, we shifted the burden of controlling the control of the service of that notice of garnishment away from the sheriff and back to the creditor or the creditor's agent. You can still use the sheriff. So at the beginning, this notice of garnishment to the debtor, in the past, the sheriff would want you to send all of your execution documents to them with a check in advance, and they would just send out the documents and serve those as the process went along. You can still do that, or you can keep that notice of garnishment and have that sent by a process server or the sheriff yourself after the interrogatories are filed and the return of service is filed with the court. So that gives you a little bit more control on fees and costs and when you maybe want to use that, send out that notice of garnishment form. Many practitioners still just use the sheriff and do it the old way and rely on the sheriff to get that sent out in the right timing. I will point out that the Attorney General was very adamant that the creditor would not, creditor or creditor's counsel itself would not put this notice of garnishment form in the mail. They were very adamant that I needed to use a process server or a sheriff. So I will note that during the legislative process itself, that was a sticking point for the Attorney General's office. So instead, I send my stuff out to my process server when I send my stuff to the sheriff, and I say, Julia, I'll give you a call, and you can drop this in the mail after I hear that the bank has returned answer of interrogatory saying they have some funds. And so she's just on standby and drops it in the mail after we get that notice that the bank does in fact have some funds. I might be jumping ahead a little bit, but that's are the first three changes. The next three changes, number 4, we now require by statute the sheriff to e-file the bank's answers to the sheriff interrogatories. That will also have your affidavit of service on it, which will show when the bank was served. But the sheriff is now required by statute to actually e-file that, and you should get notice then when the sheriff sends that, files those interrogatories, and you should get notice then on your e-file system as to what the garnishee's response was. And if the bank says no, there's no funds there, then you have no need to send a notice of garnishment to the debtor. If the bank's response says yes, we have funds, congratulations, you've got a hit, that is the trigger then for the notice of garnishment to the debtor. You have 7 days from that e-filing to send your notice of garnishment to the debtor, which is Form 308, which we're going to talk about here. So that's our new form, that's our sequence of timing, that's our trigger now. Instead of sometime 7 days after the sheriff serves the lender, you now have 7 days from the time the sheriff e-files that garnishment interrogatories. Lastly, we removed the redundancy of serving a notice on the attorney of record due to the e-filing, but also because we heard from debtors counsel that they weren't representing that particular defendant through the execution process, and it was just kind of a waste of their time. So we thought, well, the e-file covers the notice provision, and you're serving it on the debtor within 7 days of the sheriff filing the answer to interrogatories. So this, hypothetically, we were talking about the timing window. You know, Judge Vader says 0 days would be great, 120 days is too late. We were trying to really work with what is the right time frame? What is reasonably calculated notice to a debtor? So as not to give them the heads up, you know, before maybe the lender puts the levy in place, but also to give them reasonably calculated due process. And we came up with essentially the 7 plus 7 days, but potentially, as you know, the garnishee, the bank has 20 days to actually send the answers to interrogatory back. So you potentially could be looking at 34 days. The committee, the working group and the committee came up with these recommendations. I think we were at a 7 or 10 day window. Attorney General and the county attorneys thought 7 was sufficient, so we went with 7 business days. So those are your key timeline. These are the 2015 summaries. Here's the form. This is the big takeaway, I guess I would say. Your new form for notice of garnishment. If you've been using, like Jeff Porter in my office, we've been using the same notice of garnishment and our same writ of execution, you know, form set for years. We've now revised those forms to reflect the 2015 changes. Recommend the same thing for you. This Form 308 was drafted by the Section Council and is uploaded and can be found at the hot docs for the Iowa bars, the Iowa docs forms. So if you're looking to see if your form's up to date, I've circled some of the key provisions that were changed. On the top left, you'll see Form 308. On the right there in the pleadings caption area, you'll see it's reference 642.14a. And then you'll also see number 6. I always look for number 6 in my forms because this is the one that the county attorneys just fell on the sword about. They really wanted this provision in there, and it has to deal with collection of criminal penalties. So to me, if I've got number 6 on my form, I've got the new form. If I don't, I need to get into hot docs and get the new form pulled up. Again, this is the notice of garnishment form that goes to the debtor. Some sheriffs will require you to send all of the execution documents with, you know, right at the front of the garnishment process. Others, in my practice, my preference is to hold this form back to see if I've got a lender that actually is holding an account for my debtor. Then I'm not spending extra fees and costs with the sheriff to send a notice of garnishment out, A, if I don't have a lender with funds there, and B, that they're not sending it out too soon. Just Christina's way of doing it. I guess I want to open it up for some discussion. If there counsel in the audience or online here, if you have some experience with this or concerns about this or tips, certainly want to give some opportunity for those in the audience here to, you know, do you have questions? You know, I kind of started from a position that you maybe understood the execution and garnishment statute procedures to begin with. But the real key here is the sequence of timing has changed. Where you used to send your notice of garnishment at the end before you condemn funds, that needs to happen at the front end. And a debtor's counsel could certainly argue that you didn't follow this procedure timing-wise, and therefore, the remedy is that you're not allowed to condemn those funds when you go forward. Plus, you're risking a potential constitutional violation. My risk management, counsel doesn't like that at the firm. But, are there questions from the audience about tips or concerns? Mr. Kramer.
For the good of the order, we had my first litigation on some of these issues already. Only the district court level then we got appealed, so it's not really helpful. But debtor's counsel, I don't see it here, I think, but argued that we had done a notice right at the start of the writ before we even started the garnishment process, just to make sure it got out plenty early. And he argued that we gave it too early. Debtor's counsel also then argued that in spite of the statute that due process required you actually to list each creditor and to send one of these for every single creditor that you garnished, so that you would know which garnishment it is that the person would need. And so we did, I think, 3 garnishments, but we sent one notice that just said, here's all of your rights with respect to all of them. Those 2 issues, I guess.
Okay, so for those on the web, I guess I'll repeat the comment. Okay. So Mr. Kramer shared with us that this has come up in litigation where they actually sent their Form 308, their notice of garnishment, to the debtor on the front end, and it was too early. And you won that issue, it sounds like.
I did.
Okay, and then the second argument was that on your notice of garnishment form, the debtor argues, you should list each of the garnishees. You should list Wells Fargo. You should list Remax Real Estate Concepts because they're selling a house and there's proceeds. Or you should list my grandma who's about to die and the inheritance levy is out there then for 120 days. And that's the debtor's argument. And apparently, Mr. Kramer, you won that argument so far.
So far.
Okay. All right. So too late, too early. We still have a sweet spot right now. Okay, very good, very good. Any other experiences or concerns, I guess, from the audience as you're going through these? Any lenders in the audience, concerns, questions, lenders counsel? Okay. All right. So the takeaway is update your Form 308, brief your legal assistant on watching for that sheriff's interrogatories to be filed, because that's your timing, that's your trigger on sending that notice out. Again, this applies only to non-wage garnishments. And hopefully we've got a good sweet spot here in the middle on 642.14. All right. Here are our summaries. These were effective last July. Here we go. Moving on to our next topic, the Uniform Fraudulent Transfers Act. And so the 2016 amendments to the Uniform Fraudulent Transfers Act, you may know that as Iowa Code Chapter 684. 684 was implemented back in 1994 after the Uniform Law Commission had passed their own Fraudulent Transfers Act in 84. It took us 10 years here in Iowa to adopt the old one. But the key now is 30 years of case law has brought us forward into the next generation. And the key to the amendments here is that the Fraudulent Transfer Act is now called the Voidable Transactions Act, and this is effective now. So if you are in the middle of a 684 claim or considering some fraudulent conveyances, this is applicable to you now. So now that the name change went from fraud to void, I thought in the Galaxy theme I'd go with the void, and as a creditor's counsel, voids easily make up 50% of the universe, and while clusters of galaxies collapse, voids grow. If someone put you in random location in the universe, you'd very likely end up in a void. And of course, I think as a creditor's counsel, 50% of my cases are, avoidable cases. So that's my little creditor humor. But it really is just a name change, not likely a substantive change. So we'll get into that a little bit. But there's my void for those space folks out there. So we'll cover just the amendments here. This again came out of the Uniform Case Law, or the Uniform Law Commission. And this was proposed legislation both between the business law section and the commercial and bankruptcy law section, based again from Uniform Law Commission recommendations last year. And the purpose was to enact amendments for Avoidable Transactions Act formerly known as the Fraudulent Transfer Act. And the amendments are to reflect recent developments over 30 years of case law to clarify and codify what really is the state of the case law. So the Avoidable Transaction Act background, we just referenced that it's to update 684. We adopted our original UFTA in 94, and we've not revised it for 30 years. This isn't a comprehensive change. It's really tweaking some of what you might already know about the case or the statute and how you've applied it over time. But I'll highlight the 6 main changes here. Here's the Uniform Law Commission's enactment status map. There are 9 states that have now adopted the UVTA as the Commission has set that forth compared to the UFTA. So there are 9 states, and there are 3 still pending with this legislative session. This is key because Gary Norton and I went back and forth about choice of law provision that's now up here. And this is key because, and this is your spoiler alert, right? Depending on where your debtor is at the time of the transfer determines which choice of law, which state's law you're going to use. So you might be in Iowa, or you might be in Nebraska and be under UFTA versus UVTA. Not a whole lot of substance difference in the statute, but just to be aware of that, especially you border folks. Illinois on the same side. So, all right, and that's those are the other 3 pending. We've not heard this is as of last week. So there are 7 main changes between the Avoidable Transaction Act, which is what it's known now, and the Fraudulent Conveyance Act. This is the summary. We'll go into each of these separately. I, of course, encourage you to read the full chapter 684 as amended, but these are the highlights as summarized by Christina. So we'll jump into those. First of all, the name change. It was the governor's office calls me when they were signing this up and says, "Wait a minute, this looks like you're loosening the standards for creditors. Christina, I know you do creditors' rights work. Hang on a second. You went from fraud to void, sneaky Pete. You're lessening the standard." Truth is, we all know that the actual standard in the statute for fraudulent transfer was never really a fraud standard to begin with. Instead, as you know, the transaction did not have to be fraudulent in order to be voidable, even under the old act. Essentially, the standard was this. If the transaction was made when the transferor's debts exceeded its assets, or the transfer had that effect, it was voidable. So it wasn't really a fraud standard to begin with. Also, the action didn't have to be a transfer to be voidable. That's why it's now voidable transactions as opposed to voidable transfer. Voidable Transactions Act suggests that it doesn't have to be a transfer. It can be really mere occurrence of a debt. Debtor goes out and gets a new mortgage, and that's in fact a voidable transaction, something like along those lines. So the big change number 1, we are now not UFTA, we are UVTA. Mr. Norton.
Well, one of the things that's interesting in guiding clients when you're dealing with this particular area of law and trying to make them not do a transaction or a transfer that brings this into play is that it scared. Apparently, I'm supposed to use the mic for purposes of our folks online.
It's not on just yet. There we go.
Thank you.
Is this thing on?
Sorry for the trouble. I started to say that in guiding clients in dealing with this particular area, one of the things I have found over the years is that if you use the term fraudulent transfers, it scares the hell out of them. And they all of a sudden back away from the transaction or transfer entirely. And they're worried that they're going to be committing some sort of crime or bad thing. And it's really hard to make sure that they get it. And frankly, just using this terminology actually makes a lot more sense for purposes of actually describing what's going on. But that was one of those things I just thought was interesting as time has gone by, so that we've actually gone to this concept when it really was that way the whole time. And I've been trying to tell my clients that for 25 years. So finally the legislature and the ALI, and the accused will finally got it too. So.
Thank you. So that works on our benefit as well, the voidable transactions. Summary number 1 for name change. The second one, and this is the one that I alluded to earlier, I wasn't so excited about this change at first when this came over, and kind of went back and forth with Gary and a few others about, well, do we want to adopt what the Uniform Law Commission is saying for choice of law here in Iowa, or do we want to somehow make this more favorable for us, and especially in the ag and the land state that we value here? We ended up coming down on the side of adopting the Uniform Law Commission's recommendation. And here's the change. Following litigation of which state's fraudulent transfer law was applicable, Section 10B of the new Act provides that a claim for relief under the UVTA is governed by the law of the jurisdiction in which the debtor resides at the time of the transfer. So hypothetically, we're thinking, okay, I'm going after Nicole. Nicole's got a condo down in Scottsdale, and she owns, she's part of a trust that owns some land up there in Webster County, and she sells the condo. And, you know, I think this is a voidable transfer or voidable transaction. You know, the question of whether I would use Scottsdale's law or Iowa law, sorry, we ended up coming back now with the Uniform Law Commission adoption. We would be using Iowa law for all of those transactions. It's all applicable to where the debtor resides at the time of the transfer, as opposed to having 3 or 4 different laws applied depending on where the asset was located, for example. That's kind of the debate. So we came down on the side of where the debtor resides. That is the choice of law provision that is now codified here in Iowa. And it also, Section 10 also sets out some rules for determining what is the debtor's location at the time of the transfer. So put that, you know, read that one tonight when you're looking to get some sleep. But the choice of law provision is the second summary. The third main change has to do with evidence and burdens and shifting of burdens of proof. So there's 5 sections applicable regarding the evidentiary changes. Essentially, we're providing uniform rules for the burden of proof and standards of proof for the UVTA. So first I'm going to start with presumption. So, you know, is it presumed to be a voidable transaction or not? If the debtor makes this transaction, you know, who has the burden? Where does the presumption lie? And 2B was implemented to explicitly provide that a debtor who is unable to pay the debtor's debts as they become due, other than a result of a bona fide dispute, is presumed to be insolvent. And the presumption then imposes on the party against which the presumption is directed, so then the debtor has the presumption, to prove the non-existence of insolvency is more probable than its existence. So we've shifted to a presumption to the debtor that they're presumed to be insolvent if they are unable to pay their debts as they become due. The burden is still on the creditor under Sections 4 and 5 of the Avoidable Transaction Act, and so where a creditor is seeking to declare a transfer or a transaction void, the creditor still has the obligation and still is allocated the burden of proof. So you still have the initial burden, and then it shifts, those sorts of things. Those are found in both Section 4.5 and then 2B. The one that I really wanted to talk about was the standard of proof. And again, this is the one where, you know, I kind of got called out like, hey, it looks like you're lowering the standard here, Christina. I mean, this is it used to be a fraud case, now it's voidable. The standard now is codified for standard for the standard is a preponderance of the evidence, not a clear and convincing. So for fraud, you had a clear and convincing standard, whereas for normal civil cases, you had your preponderance of the evidence. The statute codifies that you don't have a fraud standard. This is not a fraud act, as Gary said. This is a voidable transaction. It's not fraud. And so the statute does, in fact, dispose of the fraud standard and the confusion that we've seen in case law over 30 years and adopts a clear or a preponderance of the evidence standard as a normal civil case. And again, this is consistent with the principle that it's voidable even though it may not reach like a level of fraud. So the standard of proof is in fact your standard civil litigation standard of preponderance of the evidence. You're more likely than not a clear and convincing fraud standard. I know, right? I totally, I got called out on the curb, like, you're lowering the standards. Actually, it's consistent with the voidable argument, not a fraud case. So didn't really change the law. The fourth change, the fourth summary of the amendments is that we deleted special definitions of insolvency for partnerships. So 30 years ago, when the UFTA came into effect, we didn't have a lot of the statutes and legislation about partnerships and how partnership interests were treated. And so under the UFTA, partners had that personal liability exposure. The key with the UVTA actually is more in favor of the debtors in this situation and actually does follow along with the state law on how those partnership interests are treated. So if a partner here in Iowa wouldn't have in that particular partnership personal liability, they are not implicated with personal liability under the UVTA. It just seems consistent with the state's application of partnership law and development over time. So fourth big change has to do with partnerships. Number 5 deals with defenses, and if you're into some of these, it's a little bit better to read those statutes themselves, but I'll do my best here to summarize a few of the key changes. So the first one, they're revised generally. The general statement from the ULC, the Uniform Law Commission, is that Section 8, the defenses generally, are revised to refine relatively minor respects of several provisions, and specifically, talking about 8A, the UFTA right now includes complete defenses for good faith and reasonably equivalent value. But the Avoidable Transaction Act adds a requirement that the value must have been given to the debtor itself. It's just one additional element in order to use that defense. 8B comes out of Bankruptcy Code 550A and B and creates a defense for a subsequent transferee. That's how the case law was playing out anyway, and it seemed to be good law to include that statutorily. And so here we are, we've reworded and clarified that provision, that defense, to allow subsequent transferees to invoke that defense a little bit easier, more easily, and aligns more with 550A in the Bankruptcy Code. Lastly, a defense to highlight is this E2. And this talks about transfers under Article 9, the strict foreclosure versus a partial conveyance or a partial satisfaction of your obligation under Article 9. And I don't want to get into the next topic of UCC updates, but should you fall into one of these situations for your transaction, take a look at 8E2 and the applicable defenses that may exist there for an Article 9 transaction or transfer. So that was updated as well. All right, and there's only 2 more. So number 6, again, this is codified to reflect the updates for limited liability companies over time. What we were finding is that some states, such as Iowa, authorize the creation of series LLCs, and where each series organization within the LLC was treated as a separate entity. Our LLC statute in Iowa does treat each entity as a separate entity. However, not all states make that clear, that every series is a protected entity. Series is an entity. So the new amendment, UVTA, is designed to show and to complement those, again, state law limited liability statutes, and suggest that whether or not a series organization is explicitly regarded as an entity or a person, under the UVTA, it does apply. UVTA does apply to each of those series entities in which the organization would engage. So essentially from one LLC to another LLC, that could be considered a voidable transaction. Lastly, we update record versus writing to be, I guess, more consistent with the technology and to identify more closely with like our Uniform Electronic Transactions Act and the MBCA, which replaces the word writing with record. And then we added a definition of record, tangible medium, stored either electronically or in hard copy. So just so There's no weaseling around or no dispute as to what writing. It's not a writing anymore. It's now a record. So those are the 7 main changes under the UVTA and Iowa Code 684. Name change. So we now have the Avoidable Transactions Act instead of the Fraudulent Conveyance Act. We have a choice of law, so where the debtor resides at the time of the transaction, that's which law is going to apply. Our evidentiary matters, definitions of partnerships and applicable provisions for LLCs, defenses, and then updated writing to record. These are effective immediately. They were signed into law a few weeks ago. So we are now under the UVTA instead of the UFTA. Again, no major substantive changes, but certainly a title change, and if you're updating your petition form for a Uniform Fraudulent Conveyance Act, throw the Avoidable Transactions Act in there instead. So that takes us through the 2 main topics for today's presentation. There's materials in your handouts that actually include the statutes as revised, so you can see kind of the red line changes if you're interested in all the particular word strikeouts and replacements. But I also include that form for the Notice of Garnishment, 642-14A, that Form 30A. So if you need to replicate that language in your own Word document form, or if you are actually a recipient or your client is, as a debtor's counsel, is a recipient of the old notice form, I would propose to you, unless it's John Kramer or I on the other side, no, I'm just kidding, I would propose to you that creditor is not following the current state of the law and potentially has a constitutional violation on their hands. There's an article in there about the garnishment statute from last year, and then the UVTA update. I have a number of materials from the Uniform Law Commission if you want some more on that for the UVTA. Those are also available just by Googling the Uniform Law Commission. They've got each of their provisions that they're working on around the country set out real nicely. You can just click through some things. If you want to get a status update on that map, that's from their website. So those are the 2 topics we're going to officially cover today. But at this point, and I don't want to get Gary off timing too much here, but at this point I did want to take some discussion from the section and those online as well. Let me first start, are there any questions from the presentation? Yes, ma'am.
Doesn't this revised Uniform Voidable Transfers Act also affect the statute of limitations?
The question was, doesn't this Voidable Transaction Act actually affect the statute of limitations? I'm not aware that it does.
684.9, they changed it from 5 to 4.
Well, apparently it does. So we have a 4-year look-back period for our transactions then. Thank you. Are there any other questions about the presentation? Yes, sir.
Winding back to the garnishment, if it's not done, if a replevin or, garnishment is not done pursuant to the code, what's the penalty? You mentioned Texas once, and every time I see something bizarre being done, they tell me we're from Texas. I even had an attorney tell me we're from Texas. So when they do this Texas style and do it wrong, what can you do in defense of your client, or what can you recover for your client?
I'm glad you brought that up. There was a lot of discussion of remedy. What if the sheriff doesn't serve things right? What if the creditor doesn't follow the procedure right? Is the whole garnishment thrown out, voidable? Is it a constitutional violation? I would submit to you that those questions are open. We were unsuccessful in codifying any penalty for the sheriff, as you could imagine, for not following the procedures. But our big concern is that we're being accused of using the clerk and the sheriff as our agents for violating constitutional rights. We wanted to be able to have some checks and balances there. The best thing we've got is to require them to file the notice so that we could at least be in the loop. But your question is an open question, and I would submit to you that we've seen everything from a challenge of the particular garnishment, that it would be voidable, to we've not seen yet anyone accuse this or identify this as a constitutional violation yet. But I would submit to you that there's certainly room for a question on remedy here. Other thoughts? Anyone have any other experience practically on how that might play out or has played out? I would challenge, you could quash the garnishment, right? A motion to quash? Yes, sir.
So here's my concern. You get the notice from the sheriff that you know, the notice, or excuse me, the garnishment was effective. E-files.
Right.
Sheriff e-files. Contact the sheriff and you say, okay, sheriff, we've got 7 days.
Right.
Sheriff doesn't get the job done. What do you do? I mean,
I wouldn't condemn my funds. I'd be careful of condemning my funds.
You're not going to condemn your funds, but then are you opening yourself up to playing with, you know, the debtor saying, well, you get service done?
Right, I think that leads to a strategic decision. Do you continue with your garnishment? Do you release your garnishment early, start it all over? Are you a risk taker? I mean, I would submit to you that I would start my garnishment over. I just don't want to be the law firm that's sued in Southern District of Iowa.
But isn't the safe thing is always to have the notice of garnishment served right away rather than wait for the 7 days?
Absolutely, that's a technique. But then again, you're still relying on the sheriff to send it out, and it needs to be sent by certified mail. Are they going to send you an affidavit that says, I put this in the mail on such and such date so that you can compare your 7 days when you have to prove up your condemnation application? I use my process server. I use my trigger of the e-file date from the sheriff, but she's also $35, and Webster County, I think, is in like $185 right now for certified mail service.
So is your procedure always to go have the sheriff do personal service versus certified?
No. No, my procedure is to use my process server to drop it in certified mail to my debtor. My procedure for serving the bank garnishment is to use the sheriff to do that because they have to do that one. Yeah, but as far as the debtor piece and my notice of garnishment, I try to not send it to the sheriff to do just because I want to maintain that control and save a little bit of cost. But I don't remember which county it was recently. They did require me to send it all up, and it wasn't worth, it wasn't worth this dispute because that's just how they've always done it. And I was like, well, 642.14a doesn't require me to use you anymore, but, it's not worth the discussion. We sent it all at once and paid the fee. Good question, though. It's a strategic choice. What do you do if this wasn't, if the timeline wasn't met? The remedies are still an unknown question. John, any thoughts on that? We went a little bit round and round in the committee level on some of that.
Definitely, I argued and continue, I argued in the committee and continue to argue that it doesn't create a remedy. And the whole issue is notice. If you have actual notice to the debtor, if there isn't actually a harm because they don't, it's not exempt, whatever it is that you're doing isn't exempt in the first place, then there isn't a remedy, there shouldn't be any remedy because you're doing everything appropriately. This is all very much a belt and suspenders type approach to make sure that people have notice. If you've given them notice, that's great, but ultimately, if there's no exemption anyway, there shouldn't be any remedy. It's a no harm, no foul circumstance. But definitely, the committee had enough people on the other side to say we want to leave that an open question. We'd rather not have that be clear, so people can make whatever arguments they want to, and if they want to argue that the entire garnishment should be quashed, then that'll now be up to courts.
I would also submit to you that kind of your catch-all provision is Judge Vietor's phrase of reasonably calculated notice. That was the real question. So have your procedures provided reasonably calculated notice? That's an argument you might want to use. Fair to say?
Yeah. And as a big one, which was discussed in the committee as well, is there is an e-file, right? So even though whether the attorney is still a record or not, or whether they've withdrawn or not, the debtor still has access to the e-file. The sheriff, the service of the notice of garnishment, interrogatory responses that there is in fact something there has been e-filed. It's a matter of public record, no matter what kind of case it is. So that's a second notice. So as a creditor, when they're saying, hey, we didn't get the one notice that you sent by certified mail, well, yeah, that's true, but you had to notice 7 days before that because it was filed in the case. It's perfectly available in the case, and if you know that your counsel is withdrawn, then don't you have an obligation to then register and start getting notices through the e-filing system. But there's at least 2 notices that are statutory required.
We'll also mention that, what about the fact that the debtor actually got notice of the lawsuit to begin with, right? They were personally sued with the petition. They personally, went through that process and had a judgment entered against them. Are you kidding me? You didn't have notice that you owed money to someone? Judge Vader says, that argument was raised during arguments on the summary judgment. Judge Vader says that's totally different. That has to do with the petition. That doesn't have to do with the actual order to levy and the deprivation of somebody's financial rights at the end of the case. So don't try and use that argument. It may or may not fly. The reasonably calculated notice seems to be where we come down on it. Other questions or concerns? Do we need to take a third shot at this one, or we'll see how this one plays out? So far, the County Sheriff's Association has been okay with it, but there's certainly room on both sides still and some unknown questions with that. I do want to take just the last few minutes to solicit any, were there any questions, I guess, from those? No questions. Okay, thank you. I did want to solicit a few hot topics or concerns that may come up in your practice as far as the commercial area or bankruptcy litigation area, as we will be preparing for next year's seminar and our legislative affirmative legislation for the next session. Anything that's real albatross or hot topics, questions? All right. Okay. Well, seeing none, I apologize. We have our firm strategic planning retreat overnight, trust falls and all, in Coralville tonight and tomorrow. So I actually have to leave early from the seminar today. I apologize that I can't be with you, but I'll be around for a few more minutes if you had specific questions in your scenario, maybe that you're working through. And you can find me at the NIMASTER firm on the website. I'm happy to take calls on if you're running through one of these roadblocks or challenges. I can at least give you my impression based on all of the committee work where we saw maybe some of those fall out. Thank you. Thank you so much, Desiree. Again, great job putting the program together and spearheading us today. With that, thank you.